a lot of our advice has been go see a lawyer, go see a lawyer, go see a lawyer. And I'm sure everyone is thinking, I don't want to pay a lawyer. And a lot of these claims that we've been talking about today, one of the relief in the statute is your attorney's fees. So there are cases where if you're not being paid properly, discrimination, things like that, you can get your attorney's fees back for them. And so we evaluate each case, and if we take it on contingency, we get a piece of what you ultimately receive, but you don't pay anything up front. And so I think that's really important for listeners to know.
That's really helpful, and that's only in the case though if you win, right? If the claimant wins, or is that, how does that?
So I would say yes. If you want every penny of your attorney's fees, you have to go all the way to the end, rule in your favor, and then the judge still has to say that they're reasonable. What they're really good for is a hammer for settlement. And so when you're talking to the employer, the employer is not, unless, it's in your contract, the attorneys, they're not getting their attorney's fees back regardless. And so while the case goes on, their bill is going up and up, and they have the possibility of having to pay us our damages plus the attorney's fees. And so that's really where that comes into play.
So the risk is really higher for them in the long run, especially if there's any sort of gray area where they think they might not, clearly be in the right.
And to build on that, when you're suing an employer for not paying wages or not paying overtime, we would get our attorney's fees back. And so that is a hammer that would help us facilitate settlement. However, when you come in and you're a high-level employee and you're getting paid a lot of money and you've usually signed an agreement for that employment, a lot of times there will be a fee-shifting provision in that agreement. And what that'll say is that the winner of this lawsuit gets their attorney's fees. And so that doesn't necessarily now always put it on the employer. Now, if you've breached your non-compete, you've breached your non-solicitation, you're, in breach of this agreement some other way, and now your employer sues you, you could be liable on the hook for their attorney's fees. And that acts as a hammer for the employer more so than it does for the employee, especially at a high level. And so that's another reason why before you sign these agreements, if you're an executive or, VP level person, you really should have somebody look at them.